Welcome friends. Today we are going to start a discussion on fundamental terminology of Hindu law. This is the week 1, module 1, lecture number 2. I am Dr. Anup Kumar, faculty of Law, Banaras Hindu University. Welcome you all at SWM platform. Friends, before starting anything, I want to recall what we discussed in the last class. In the last class, we tried to understand the meaning of Hindu law, evolution of Hindu law, concept of Hindu law, and applicability of Hindu law. We understand that law which regulates the personal affairs of Hindu is known as Hindu law, and Hindu law is personal law. It's not a territorial law. Hindu law is a lax fori law, not a lax loci law. And by this discussion, we understand the fundamental concept of Hindu law, which rooted from Vedas, announced in Smritis, modified and developed by the commentary and digest, and supplemented with custom and uses, and administered by the court. Today, we are going to understand the fundamental terminology. This is very crucial to understand the key concept of Hindu personal law. The learning objective of today's lecture is the learner will know the technical term of Hindu law. Every subject of law includes technical terminology. Without knowing the meaning of technical terminology, we can't understand the subject in true spirit. Therefore, we are here to discuss about the meaning of technical terms. We also focus on the real meaning of the technical terms related with Hindu law. The first is technical term and the second is real meaning of technical term. The people are confused. Students are also confused. They are not understand subject in the proper sense because they have no sense of understanding about the proper meaning of the technical terminology. Therefore, this is crucial. The learner will develop the insight towards the fundamental concept of Hindu law while he be aware about the fundamental concept of Hindu law. So these are the learning objectives of today's class. Now we are going to start our discussion. The first fundamental terminology related with Hindu personal law is Dharma. Friends, Dharma is derived from the word dhri, which means to uphold, to support, or to sustain. Brihadaranyaka Upanishad provides that Dharma is the Chhatra, power of the Chhatrasya. Therefore, there is nothing higher than Dharma. Means Dharma is superior, fundamental, and fundamental of everything. Taittiriya Samhita states that Dharma constitutes the foundation of all affairs in the world. In this world, everything founded on Dharma. Dharma refers to the set of duties and responsibilities of the individual. It is not only limited to the religion but extend to spiritual, social, cultural and legal obligation as well. The very interesting point is we are not knowing the true meaning of Dharma, therefore the people are confused Dharma with religion. We must understand the concept of Dharma. Dharma is a diverse concept, therefore Dharma not prohibits for any kind of critical thinking, and therefore in India we have no such kind of restrictions on freedom of thought and the way of worship. Dharma allows full freedom of thought and conscience. Therefore in Bharat we never recognize the concept of blasphemy. In Bharati tradition developed in Bharat around the Dharma, because Dharma is a widest connotation. In India, we recognize the concept of Dharma in our Constitution Assembly debate. Sri Raghuveer quoted in Constitution Assembly debate, the fact is that Dharma never meant and can never mean religion. I think the word Panth may properly be translated as religion, but I do not think that religion can ever be taken to connote dharma. But the Englishmen made a deliberate use of this for their own ulterior purposes. Krishna Iyer also tell us about the meaning of dharma. Dharma is the law of social well-being and it varies from yug to yug. How we can understand the approach of Raghuveer and Krishna Iyer? The panth is one thing, religion is one thing, but dharma is widest connotation, which includes diversity, which includes freedom for faith, freedom for idea and approach, freedom of philosophy. Therefore, we cannot mix the concept of dharma with the concept of religion. Therefore, Sri Brajeshwar Prasad also observed and said that dharma is in the consonance with the fundamental principle of democracy. So when we are going to start the idea of dharma, we must understand that we should not mistaken dharma with the religion, because religion is a narrow concept, dharma is totally different. In India, we traditionally accepted dharma, therefore we allowed critical thinking, we allowed tolerance, we allowed and respected the view of opponent. This is the essential feature of the dharma, and therefore dharma should not be mistaken with religion. The Supreme Court also held that a very important case, Sri A.S. Narayana versus State of Andhra Pradesh, where the Supreme Court concluded that what are the signs and symptoms of dharma? The answer is that which has no room for narrow mindedness. There is no room for narrow mindedness, blind faith and dogma. The purity of dharma therefore cannot be compromised with sectarianism. The sectarian religion is open to a limited group of people, whereas dharma embraces all and excludes none. This is the core of our dharma. This is the point. The Supreme Court well explained the entire idea, where Supreme Court discussed the difference between dharma and religion. The panth, religion and dharma. Dharma is widest concept, and therefore sectarianism and Panthian approach is not allowed in the domain of the dharma. So when we are going to start discussion on dharma, we should think that we should not mistake the idea of dharma with the idea of religion. When we are defining our tradition in the light of religion, either we are comparing Bharatiya system with European religion model, you cannot understand our tradition, because Europe followed religion, it generates intolerance, it creates problem in their system, because they are not willing to accept alternative views and alternative interpretations. But dharma in Bharatiya traditions allow and respect others and also respected the opponent's point of view. Therefore, dharma is different than religion. It should not be mistaken. It should be understood in proper context, because dharma is one thing. Dharma is associated with duty, morality, justice, but religion is only focused on the way of worship. Therefore, we should not compare and contradict with two ideas. The one idea is focusing on the worship model, and another is a comprehensive philosophy, comprehensive practice which empower us to explore our life in every context. Now the second technical terminology which is related with our discussion is Shruti. Shruti is considered an important source of Hindu law. It is a Sanskrit term that means that which is heard. It is considered as eternal. Shruti means Ved also. Therefore, Shruti includes four Vedas: Rigved, Samved, Yajurved and Atharved, along with their associated Brahmanas, Aranyaks and Upanishad. Shruti is a fundamental terminology. Shruti means Ved, what was heard by sages is crucial and important for Shruti. Therefore, Shruti is crucial and fundamental in our tradition because we explain the idea of Rit and Dharma from the perspective of Shruti. The second one is the Smriti. Smriti literally mean that which is remembered or what was remembered to the sages, friends. Smriti is the second in the hierarchy for acceptance as an authority after Shruti. Exact point is Shruti will prevail over the Smriti. Now the second terminology is the custom. Custom is fundamental in the domain of personal law because custom is the example of living law. People's daily life based on the custom, and therefore custom is a concept which should be explored properly when we are entering into the domain of Hindu personal laws. Therefore, custom nowadays also considered as the law, as a rule, and it is followed by a particular family, either particular community, either in particular area. The term custom is used in the sense of Sadachar in Indian traditions. The idea of Sadachar is totally different than Western concept of custom. Sadachar means the practices of good men is Sadachar. Friends, custom is also recognized as a valid source of Hindu law. Manusmriti also acknowledges the custom of the virtuous men as a source of Hindu law. According to the Gautam, the custom of the communities, caste, family, which are not opposed by the sacred records, have also authority. So this is the idea of custom. The custom means the custom of good people, practices of good people. To understand the good people and their custom, and then we can understand the idea of custom. Now I am going to explore the another meaning and technical term, that is the marriage. The marriage is very popular for the purpose of the Hindu personal law. According to the Hindu law, marriage is considered a sacred union, not a union which is based on the basis of contract. In India, we are bound to think marriage in a proper context. The marriage in European country, the meaning of marriage under the Islamic law, and the meaning of marriage in Indian tradition may be explained differently. And if we are really want to understand the Hindu law, especially Hindu personal law, we should know the true nature of marriage and true meaning of marriage. Therefore, in India, we consider that marriage is a sacramental union, not a contractual union. So this is the core principle and meaning behind the marriage. Very recently, in the year 2024, the Honorable Supreme Court in Dali Rani versus Manish Kumar Chanchal explained the idea of Hindu marriage. They explained that a marriage, it is not an event of song and dance, winning and dining, or an occasion to demand an exchange of dowry and gift. This is Hindu marriage which facilitate procreation, consolidation, the unity of family, and spirit of fraternity within the various community. Means in Dolly Rani case, the Supreme Court identified different concept of the marriage which is prevailing in India. Friends, we should understand the idea of marriage in Indian tradition in the context of the spirituality, in the context of the religious duty, in the context of the sacramental union. Therefore, we have no scope for the contractual union, and therefore law should not be interpreted and applied when we are interpreting the Hindu personal law in a reference of marriage. We should be think that our idea is based on the sacred union, and therefore everything should be interpreted in the same direction. Therefore, the meaning of marriage should be very crucial for the purpose of the Hindu personal law. Now I want to explain the term Sapinda. Sapinda means same pinda, means the meaning of Sapinda may be categorized into broad category on the basis of the understanding of Mitakshara and Daibhag. The Mitakshara means two are connected with the Sapinda relative because they have same blood particles in their body. And in Daibhag, the concept of Sapinda is based on the spiritual efficiency, whether you are eligible to offer Pindadan to deceased men or not. On that basis, we are able to explain the Sapinda relationship. Friends, under the traditional Hindu law, we recognize the concept of Sapinda for three purposes. The first is for marriage, for succession, and from other context. Now, in the present legislations, we recognize the concept of Sapinda in reference to marriage only. The marriage between the Sapinda relatives are not allowed by the Hindu Marriage Act section 5. So this is the Sapinda relationship. This is the unique concept which developed and originated in India, which not permitted a person to marry with a close relative. Now the second concept is the prohibited degree relationship. Hindu Marriage Act primarily also prohibits marriage within a gotra, but now after the enactment of Hindu Marriage Act, we diluted the concept of the Sagotra marriage, and now we focusing on a new definition, that is the prohibited degree relationship, which is particularly defined in Hindu Marriage Act, where certain relatives are recognized as a prohibited degree relations and where marriage is not allowed. But this restrictions is not absolute. If customs permits, then marriage may be allowed within the close relatives. So this is the concept of Sapinda and prohibited degree. This is very crucial for the purpose of explaining the idea of Hindu marriage. The concept of maintenance now recognized by the Hindu Adoption and Maintenance Act, where we focus on the provisions for goods, clothing, shelter, education and medical care. Additionally, the law also provides that in a case of unmarried daughter, the maintenance also includes reasonable expenses about marriages. Question is, why we have a liability of maintenance? The liability of maintenance lies due to the natural relationship. The naturally husband is liable, father is liable, father-in-law is liable to maintain the family member. Now the next concept is adoption. Adoption is also very crucial in our traditional Hindu law. We recognize the idea of adoption in a form of Dattak Vidhi. Dattak is allowed because everyone is bound to discharge the religious obligations. Therefore, in Indian tradition, we recognize the son for the salvation as well as for the discharge of the duties and liabilities in the physical and material worlds. Therefore, at present, we also recognize the concept of adoption, but the fundamental rule is, so long as you have a son, then you can't adopt another son. If you have a son, grandson, great grandson, you can't adopt son, and simultaneously the rule is also applicable in the case of daughter also. Now with the reform of Hindu personal law, Hindu wife and Hindu husband equally capable to take adoption. Now I want to focus on a concept of joint Hindu family. The concept of joint Hindu family is crucial in order to understand the concept of property and the concept of succession. Why? Because joint Hindu family is a natural relationship, a natural union where lineal descendant from common ancestor and also includes their wives and unmarried daughter. Joint Hindu family is not joint only in state but also in the food and worship. The concept of joint Hindu family is very relevant. Why it is relevant? Because this composition is fundamental of Indian society. It is very crucial for the observations of dharma, legal duty and obligations, and therefore we accepted the concept of joint Hindu family as a fundamental concept of Hindu personal law. Now another concept is the concept of coparcenary. Coparcenary is a narrower institutions which exist within the joint Hindu family. The idea of coparcenary is recognized under the Hindu personal law for the purpose of regulating the property. The coparcenary means last holder of the property and next three generations. Traditionally, we recognize the idea of coparcenary only in the context of male member, but by the amendment in the year 2005, now we recognize the concept of coparcenary in the context of daughter also. Now, son and daughter equally recognized under the concept of coparcenary. But coparcenary as a institution to be understand properly, because this is a unique concept for the purpose of regulating the property of joint Hindu family. Friends, the idea of per stirpes and per capita succession is also given under section 19 of the Hindu Succession Act, which means that when in a case of dissolution of the property, everyone accept the property personally, where the law prescribed, then you may receive the property branch wise. Suppose in a case of deceased son and deceased daughter, their descendants may acquire the property on as a representative of the deceased person. Now another concept is the concept of Stridhan. Stridhan is a unique concept which is prevailing in India, where we talks about the certain property which is absolutely associated with women. Therefore, we recognize the concept of Stridhan. In Manu Smriti, Manu noted that Adhyanavikam Dhyanvikam Dattam cha Priti Karmani Matri Bhatri Pitra Dat Shadvidyam Stridhanam. 6 kind of Stridhan explained by Manu in Manu Smriti. And especially under section 14 of Hindu Succession Act, we focus on the property of Hindu female, where we explain the property of Hindu women includes Stridhan plus another property. So now the idea of 14 is wider than the concept of Stridhan, but Stridhan is a traditional concept which prevailed in Hindu law, which recognized the absolute right of Hindu women over the property. Now the next concept is a Karta. Karta literally means manager of joint Hindu family. Karta is responsible to maintain everyone. Karta have absolute rights. Not absolute right, but also restricted rights. Karta cannot alienate the property generally. Karta may alienate the property in different contexts. For example, Kutumbarthe, Dharma Marge, and as well as for the development of the property. Generally, senior most male Hindu member recognized as a Karta in joint Hindu family system. Now the fundamental question is, on the basis of the discussion, what we can think about that. Is religion an appropriate term capable to convey the meaning of dharma? This is the fundamental questions. We can't evaluate our social system on the basis of religion, because religion is totally different than dharma. So therefore we think again when we are using religion as a synonyms of dharma. So this is the point where we should focus again and again and realize and trace the exact meaning of dharma. The second point is how dharma can be placed in a legal system for justice, because dharma is a wider concept. How we can be closer towards the idea of justice with the path of dharma. The third point is how true meaning of the term is useful to understand a subject in its letter and spirit, because without knowing the technical meaning of terminology, we can't understand the meaning of the term. Therefore, I want to summarize today's lecture. We discuss the point. The first is dharma and religion. We should be very careful when we are using such kind of expression. We also discuss about the Shruti, we also discuss the Smriti, we also discuss the concept of coparcenary, joint Hindu family, custom, Stridhan, law of succession. These are very fundamental key terminologies. Therefore, by knowing this, we become capable to understand the subject properly. For your attention, I am very thankful to you all. Thank you very much.